Good evening, ladies and gentlemen. I think, first of all, sincere gratitude to the esteemed panel for taking time out on a very, very busy Sunday evening. I'm sure there are better things that they would have loved to do. So thank you for that. The topic for today's discussion is essentially risks of compliances and how businesses are essentially having to look over their shoulders for these compliances. So Dr. Anand, I'll just start with you. I think the first question is that you, of course, have had a very long history of litigating at all courts, etc. So in your experience, what sort of issues would you say are the most prominent and relevant ones that come up as far as compliances are concerned with respect to companies? And if there is any learning that you can share as to what the companies can do to avoid such issues.
I am Ms. Shah, I'm not Ms. Anand, so just a clarification, but thank you anyways. I'm a litigator and I practice in the field of intellectual property. So I will give the perspective of being a litigator, what kind of compliances which generally the industry find very onerous, starting with the patents, which is kind of a exclusivity which is given for a very limited period of time, which is 20 years, and the grant itself takes 10 to 12 years and only 8 years left to exploit. There are certain provisions under the Patents Act, which I think have kind of created a lot of onerous task on the patentees to kind of fulfill, and it doesn't serve much purpose because we have moved ahead of time. When these provisions were made, there was no internet kind of thing and the data was not very accessible. So compliances like disclosure of related patents or the family of patents to be made, and it is to be made within 6 months. And thereafter, you have to continue giving those information of the global level. You know, it's not only of India, in whichever countries you have filed. And thereafter, if the controller wants to seek more information, you have to provide that as well. That so far so good, but the consequences, if you have failed on any such information, either by oversight or by mistake, because generally a patentee files patent in 40 countries or 50 countries and data can be very huge data. If you have failed to file such information with the government, then that becomes a ground for invalidation. Now, this provision, when it was made, this was not the era of easy access to data. So I think this provision has outlived its purpose and it becomes very cumbersome. That example. I'll quickly take another example, which is filing of Form 27, which is working of patent. Because when you go and enforce a patent, the court will only grant you injunction if you're working the patent. And you have to file annually the forms that you are actually either working yourself or you're working through your licensees. And if you have not filed again, there are inferences, or if you have given a wrong data or some data which may not match, it has a penal consequence also provided. Now, initially, like India is a TRIPS compliant country, and when the provision was enacted, it became that local manufacture will only amount to working of patent. But over the period of time, this provision has kind of given judicial interpretation where now it has been clarified in last 4 or 5 years that even import would amount to working of patent. So the point which I'm trying to make is this. There were provisions which were made a long time back, which have probably required a fresh look. Courts are, through interpretation, giving it a wider and a viable meaning. But if conventionally it was drafted, and if it will remain like that, it is becoming very onerous. Likewise, if you see in the field of IT, because I do a lot of information technology matters also. If you see recently, there has been a development and there is a lot of compliances which has been put on the intermediaries, like, appointment of nodal officers, grievance officers. The compliances are 24 hours. And there was a desire of the government to have a data center in India. Now you can understand, if every intermediary has to do a business in every country and you have to put your data there and the server there, a kind of investment would be required. So it's a very tiring provision, I would say, and a lot of stress on the business, because the compliance is of such nature and the consequences of such nature, which kind of put you to think whether India is a country very conducive to do the business or whether you should refrain yourself. Thirdly and lastly, I would say I'll take one more industry, which I am very kind of closely working on, is the Insecticide Act. Under the Insecticide Act, since the product itself is a very poisonous product and there are requirements that safety, efficacy of the environment and the kind of human being is the kind of objective. But under the Make in India mandate, the government is now asking that you manufacture those things in India, which is kind of each progressing, developing and developed countries are not making it indigenous. They are having their manufacturing unit far away from kind of places where the hazard is less. But without, focusing much on that, what will be its effect, you are driving Make in India policy for the industry, which is maybe completely, contra purpose. Lastly, in the field of IT, the customs, we enacted in 2007-8 some rules where, if any counterfeit goods are imported in India, you can register your brand there and any suspected goods will be interdicted. But now when you are a brand owner, you are facing the problem of counterfeit, you are expected to file a security bond to the cost of 110% of the value, surety bond, and those bank guarantees which you submit in the form of bank guarantees remains unreleased. For last 7-8 years, those bank guarantees are just blocked. So I think these are the compliances which are really, really very, very difficult to handle for the industries. Thank you.
Thanks, Mamta. I think you raised a very valid point on the whole data localization, and I personally am a corporate commercial lawyer, but I do sometimes wear a regulatory lawyer's hat as well. And just to share an example with you, in one of the matters that I was doing, and this is as you're all aware, that RBI law now mandates that financial transaction data has to be in India. And this is a very large payment settlement company, which I'm not going to name, but because of the fact that they had to localize that data into India, the IT person who was there essentially wasn't really trained on how to do it. And there was a data breach, which led them into a whole 6-month process of going back and forth with the RBI for breach of a compliance which was put on them without public consultation, without anything. So yes, I mean, I can totally understand. Moving on to you, Farhat, I think you, of course, have worn multiple hats, both as an in-house lawyer as well as a law firm partner. And I understand that you do have multi-jurisdictional experience. Now, typically, when people, and this ties into the whole ease of doing business in India, which is a point which is very dear to our Prime Minister. But, often we hear, at least my clients complain that the cost of compliance in India is too high. Now, has that been your experience when you have seen companies or corporates trying to invest into India? And what would you say are the typical pain points when these guys are trying to invest into India as far as compliance is concerned?
Thank you, sir. Thank you, everybody, for having me here. A wonderful opportunity to talk on these important topics. My name is Farhat Ali Khan. I'm a lawyer currently in Dubai, working on and practicing on various corporate commercial matters of international jurisdictions. I've not practiced very rigorously on the on the Indian legal matters, but my experiences with terms of compliances, these challenges are certainly growing. And this is, and it is evolving month on month, year on year. The kind of enactments that we see on laws related to compliance. So I would like to frame it in two parts. When a business is to be started or conducted, compliances are typically the statutory compliances, which is the charter compliance. When you incorporate a company, when you get the registrations done, whether the GST, whether the VAT, whether the shops and establishment certificate is to be obtained, whether a motor vehicle registration is to be done if the company is into transport business, whether any other registrations are done. These are charter compliances. However, there comes in place a practicing compliance on various matters. These could be, how the business is to be conducted, how the packaging and labeling regulations are to be adhered, how the IPR regulations are to be adhered, how the new evolving compliances that have now taken a substantial role. So I wanted to discuss two important challenges that are coming. One is the anti-money laundering, which is now quite largely discussed. The other is the general data protection regulations, the data protection bill, that has now been quite rigorously discussed in India as well. So these two compliances have taken over a very large space on companies, the manner they conduct their businesses. So anti-money laundering is more of a compliance officers topic to be discussed. But of late, we've seen how lawyers have taken, an important role in dealing with this issue, with this subject, where the consequences are, very, very extreme. The consequences are not only on the companies if they fail to make compliances, it also goes on to the directors, on the shareholders, on the, money laundering officers that are appointed by the company, and the beneficiaries of any proceeds of crime. So whether it is financial service firm, whether it is a non-designated financial service provider, they all are required to follow with strict and severe measures of the provisions of law related to AML. AML, we've also seen, has very largely got associated with CFT, which is combating or financing of terrorism internationally, which is very, very largely discussed. So the link is that the moment there is any format of money laundering, it could be a mechanism to finance terrorism activities in different parts of the world. So how do we deal with this? What could be the consequences? If a money that has been obtained illegally is spent on, funding terrorist activities or funding organizations which are banned. So a lot of responsibilities of companies in dealing with this subject. There's another interesting thing that I've been discussing with a lot of my clients is that how do you conduct your trades when you enter into cross-border trades, when you appoint distributors, dealers, what kind of due diligence do you do on them to ensure that are they compliant to provisions of AML, are they compliant to not dealing with such parties that may be banned in different organizations, different territories. Let's say a manufacturer in Dubai or in the Middle East, or a distributor has appointed dealers in a jurisdiction in the North African part, and that dealer would have been knowingly or unknowingly, unknowingly is the word that has been used in provisions of AML across, has funded an activity which may be illegal in nature. So there's severe consequences. The punishments are very, very extreme. It amounts starting from $1 million could go up to $10-15 million. So this is one. The other area in terms of compliances of international trade and businesses that that have to be very, very careful is how data are managed, because today companies, they have their values, their potentials are generated on the amount of data they are holding. Now, when you have a very large amount of data, how do you process it? How do you manage it? How do you prevent any kind of leakages? And, there are situations where companies have come up which are into illegal sale of data. And that's a very large, could be $1 billion industry. These things, could lead to sanctions. And sanctions, it's another serious issue, where companies could get sanctioned, where individuals could get, face sanctions, and these sanctions could come out from the European Union, from the US, or, other international bodies, or the United Nations Security Council. I was just reading, there are currently more than 700 individuals who have been globally identified and put under the sanctions list. So these are all consequences arising out of failure to meet compliance standards in how you conduct businesses. I hope I'm not exceeding.
No, but we are aware of the time. So that's the board.
Okay, sorry. So, so these kind of challenges are very, very important in terms of how you conduct your business activities, how you prevent, and if there are violations to these kind of compliances which are mandatory, it goes directly on the promoters, it goes directly on the shareholders, it goes directly on the directors, the CFOs, the CEOs, the officers designated to prevent these kind of violations. The punishment is severe, it goes to imprisonment. So like yesterday there was a discussion why in the US so many general counsels are now facing prosecution. They're facing they're facing court trials. So because they have been negligent in managing these compliances. So compliances have become very important part in terms of dealing with business activities all across, right from the moment you start a company till appointing dealers, distributors at every level. So there are statutory compliances, how you conduct and form companies. And then there are, practicing compliances, which are very, very important. And I think AML and GDPR is something that is to be very, very regularly discussed between companies, particularly in India. I discuss AML in UK, in Dubai a lot, but I see, there's very little discussion on AML here between the legal community. Compliance officers do discuss, banking and financial services compliance officers do discuss AML, but I think, lawyers also should need to get involved into this. And, there have been so many instances. Just recently, celebrities have been hauled up. Their accounts have been frozen. I mean, they've been called, interrogated, investigated. How did they receive these amounts? Were they involved? Were they a party to, to these kind of, to sourcing of these illegal funds, or a party to the crimes that were committed, out of which the funds have been generated?
Thanks.
So, yeah.
Yeah, thanks for that. I think I'm aware of the time, so I will just like to bring in Akshay over here. And, it's an interesting segue. It's an interesting point that you made about who the liability should be apportioned to. I remember a couple of years back, the Unitech independent directors were essentially hauled up by the Supreme Court because of actions of the court. And Akshay over here, apart from being a partner at Saraf, I'm aware that was also very, very in a senior position in Indigo, yeah. So Akshay, would just love to hear your thoughts on, this we often talk about, compliance as an evil, and that's something that, we all talk about, but we know that it's a necessary evil. So there is this culture that we need to develop, the culture of compliance. A, how has your experience been as an in-house lawyer in developing that culture of compliance? And B, what do you think businesses can do better to manage the risks? Because both Mamta as well as Farhat have spoken about the risks of non-compliance. But I just want to hear from you as to how can you manage that risk?
Thanks, Snigdhaneel, for a kind introduction, first of all. And yeah, it was interesting to hear my co-panelists' views. I would just make one, distinction. I think some of the things we discussed today on the panel are not technically compliance. They're also in the realm of substantive law. For example, some bit of patents and anti-money laundering, like that's a crime as a substantive law. Someone is laundering money, so to say. When we talk of compliances, they are like what things you need to do in your ordinary course of business to do a legal business. For example, labor law compliance. If there are regulated industries, like Indigo is a very heavily regulated company because it's in aviation sector, right? So there are many compliances, and the narrative today in India linked with ease of doing business is around how to ease doing business, how to cut compliances and make them more simple, right? So before coming to culture, I think this is an important piece. So government has been doing its bit. I think it's very encouraging, like our Honorable Finance Minister declared how various provisions of Companies Act, which was a major source of compliances for any company, right? Lot of those compliances have been decriminalized or taken away, right? Which were not serving that kind of a purpose. So one is from law perspective, from legislation and government's perspective, because a lot of compliances come from rules, which is delegated legislation, right? There is a need and steps have been taken in the right direction there to simplify compliances. That's one. Secondly, coming to the companies, I think the foundation of compliances is where you understand which compliances are applicable to that particular company. And there need to be simplicity of thought process there. Many a times it's seen that, there are certain agencies who will throw an entire statute book on the companies, right? And say that, okay, everything needs to be complied without any focus on what are the critical compliances to be made. So it's very important that for GCs or chief compliance officers to be quite hawk-eyed in prioritizing which are the key compliances that need to be complied by that company. Then it comes to culture, the question you raised, Snigdhaneel, which is very important because compliance by nature is seen as a check in the box many a times, right? And people don't pay much importance to it. And this is more so in MSME segment or startups where the focus is only on product growth business and compliances kind of take a backseat. If it's a huge billion-dollar multinational, you won't have this problem because they have experts and professionals taking care of this. But this haunts, as we all know. So creating that mindset and culture of compliance is important. One way of doing it is that it's a top-down approach. If the top management does bring this up in town halls, it percolates deep. Second, if there are trainings which are organized within the organization and they're rampant trainings, again, not check in the box kind of trainings, those definitely help. If the people who are responsible for compliance, if doing compliance as part of their appraisal processes, then that definitely helps it seep into the system. So yeah.
Okay. Thank you so much. I've been instructed by the organizers to not have any audience questions. I'll just take 30 seconds to sum up. I think, first of all, thank you once again so much for taking time out and doing this. I think the learning that we have out of this is, yes, I think there are compliances which are tedious, which are boring, and which we have to do. But as Akshay mentioned, that there are ways we can manage it, and we have to manage it. I think with that, once again, thank you so much for your time.